I want to talk about the case Barron v. Baltimore real quick. And no, this isn't a lesson on Barron v. Baltimore. I can tell you the basics. That's about it. Is that basically, I think his name was John Barron. He owned some land somewhere off of the water in Baltimore. Go figure. And they did some like damming of the river, something like that, that basically caused his land to get flooded out and become worthless. And he said, no, that's a violation of the Fifth Amendment. He took it to his lawyer, and his lawyer happened to be the guy who served the longest as the Attorney General, something like, it starts with a W. But anyhow, moving on here. I'm not teaching a lesson on Barron v. Baltimore. John Marshall was the Chief Justice at the time. Every justice in the Supreme Court, if I'm not mistaken, even though this case was brought by one of the most experienced attorneys in the Union at the time. I'm going to call it the Union because that's the honest truth of it. Every last one of them said, well, we all know the Bill of Rights was written to apply to the federal government. The states requested it to keep the federal government under control. And so, no, the Bill of Rights is not restrictions on the states or on the towns or anything like that. Okay, I've said this a million times, and I'm going to say it again. Governments derive their just powers from the consent of the governed. How can the governed give their consent to something you didn't write down and present to them? The Fifth Amendment does not say this applies only to the federal Congress, okay? So I don't care if it was part of the common discussion at the time. The fact is, you didn't write it down. And if you didn't write it down, then it says what it says, and that's all there is to it. And I'm inclined to go along with Frederick Douglass. I'm inclined to go along with Joseph Smith. The states' rights doctrine is a load of baloney, right? It's a misapplication of the Constitution. I'm going to go along with John Taylor. John Taylor says whether or not the people knew it when they were framing the Constitution, which Delaney jokes as he presents us in defending our divinely inspired Constitution, he includes the Bill of Rights as a major inspired part of the Constitution. Whether or not they knew it, they were writing down what God wanted them to do. What does that mean? As Jesus Christ's Gifts and Expectations by Ezra Taft Benson says, we should look to a certain degree to the prophets actually for an understanding of the Constitution. Okay, so the prophet went, for example, when they were getting attacked in Missouri and said, hey, you guys, we've got rights. You're supposed to be protecting them for us. He said anybody who's sworn an oath to the Constitution and doesn't defend the rights of someone who they could defend their rights should potentially be subject to the death penalty. Something to that effect. Look it up. So Barron v. Baltimore, all these Supreme Court justices, including John Marshall, said, nah, the Bill of Rights doesn't apply to the states. It only applies to the federal government. There is literally only one amendment in the Bill of Rights that is written down that actually bears that out, and that's the First Amendment. Congress shall make no law. Okay? That's the way it opens up. And then it wouldn't have been so hard to copy and paste that exact same wording into the Second Amendment, Third Amendment. It would have taken up a whopping total of another 30 words in the whole document. They didn't do it. But once again, whether they knew it or not, they were writing down exactly what God wanted them to write. Or as Frederick Douglass says, it's a glorious liberty document. We just aren't applying it right. But when you read the actual words of it, it's perfect. It's beautiful. It's good, right? So, Barron v. Baltimore is where this states' rights doctrine really gets a solid foothold, as I understand history. And that's what Joseph Smith hated. He hated the states' rights doctrine. And this doctrine, it's basically a way of interpreting the Constitution. I'm sorry, I speak English fluently. I don't need an interpreter, thank you. Okay? And no, the only just powers that the federal government gets are those given by the consent of the governed. If you didn't write it down, we can't give our consent to it. It's impossible for us to give our consent to it under this style of system, a written Constitution that we have. Okay? So, the states' rights doctrine, Barron v. Baltimore, it's not textual. It's not part of the original public meaning of the Constitution. And we don't need further explanations from the Federalist Papers, further explanations from backroom meetings. All that stuff is worthless to us. write it down, present it to us, see if you can get 2/3 of both houses at the federal level and 3/4 of the state legislatures to sign off on it in its written form. If you can get it, that's what it says. Whatever it says, no matter what kind of clever interpretation you can come up with, the consent of the governed was only given to what it says. So, I recently, like I've pointed out before, I debate this stuff with AI after I sit there like reading it, studying what the founder said, studying this, studying that. Then I'll be like, look, the consent of the governed wasn't given to any other wording than the wording presented. Each one of those amendments was separately ratified, right? The preamble wasn't ratified. Nothing was ratified saying this is a package deal, apply the wording of the First Amendment to all the other amendments. Nothing like that was added, okay? So therefore, you get down to, the 1830s, 1840s, 50 years later, right? Americans are looking at, all they see is what's written. That's all they see. They have no other way of understanding it except for what's written. It either is what it says it is, or it's a lie. And that's all. So, the states' rights is a doctrine thing. It's not a fact. It's a corruption. And the Constitution itself was perfect already. It was, I shouldn't say necessarily perfect, but it was great. And people just weren't reading it honestly according to what was presented for ratification. So the case is called Barron v. Baltimore, and again, it's in the early days of the founding, and yeah, brought by one of the most experienced attorneys. So this wasn't a slacker of an attorney that brought the case, and yet due to tradition, due to conversation that wasn't written down and presented for the consent of the governed, presented for ratification, the Supreme Court said, nah, Bill of Rights doesn't apply to the states. That's not the way they read. The 14th Amendment is not important. We don't need the 14th Amendment. All it does is repeat language from earlier in the Constitution, except for the fact that the whole 14th Amendment, it reads like a punishment on the southern states. It was ratified through coercive means. If it went away, the Constitution would still be just great. And that's the honest truth of it. The 14th Amendment, the fruits of it have been what they have been. You get this kind of ex parte Young doctrine, this waiver of sovereign immunity. Suddenly, like, the federal government's reviewing everything the states do that isn't relevant whatsoever. This vague terminology of privileges and immunities, this vague, worthless concept. Nowadays, if you ask me, I'm sorry, where does Obergefell v. Hodges come from? Unless you want to claim it's a 9th Amendment right? And I guess that's, that's an interesting discussion to have, right? So, states should be humble because of the 9th Amendment. So, the Supreme Court should stick to what's actually promised in the rest of the amendments. So, anyhow, of the Bill of Rights. So, well, that's my thoughts. Thanks for listening.